You have 12 days left, 12 days to get this right, because after noon Eastern on March 19th, the window closes and there is no going back. Right now, thousands of H-1B hopefuls and their employers are logging into the USCIS portal, and a significant number of them are about to make mistakes they don't even know are mistakes. Mistakes that will cost them $215 they can never get back. Mistakes that, in the worst case, could flag their registration for fraud and trigger consequences that follow them for years. If you are in the middle of this registration process, or if your employer is handling it on your behalf, you need to stay with me through every minute of this video, because what I'm about to break down could be the difference between getting your shot at the lottery and losing it entirely on a technicality. Welcome back to USA Immigration Path. While social media is full of noise about the H-1B this season, some of it accurate and a lot of it dangerously wrong, we are looking at the official text, the USCIS announcements, the Federal Register, the verified data. That is the only standard we hold ourselves to on this channel. And as always, remember that I am an analyst walking you through this system. This is educational content, not legal advice. For your specific situation, always consult a qualified immigration attorney. Now let's get into it. The FY 2027 H-1B registration window opened at noon Eastern on March 4th and runs through noon Eastern on March 19th, 2026. NBC News. This year, employers must pay a non-refundable $215 registration fee per beneficiary. NBC News, and they must also submit new job-specific data, including the SOC code, the worksite location, and the prevailing wage level for every single person they register. Those are not optional fields. They are required. And that combination of a non-refundable fee and required accuracy creates the first major trap that is catching people off guard this season. Let's talk about the $250 fee and why it is fundamentally different from anything that came before it. For years, the H-1B registration fee was $10. $10. That number was so low that it practically invited careless submissions. Employers filed mass registrations without much thought because the financial downside of an error was almost nothing. This year's fee is more than 21 times higher. NBC News, and that is not just a budget change. It is a behavior change. It forces precision, and here is the problem. The system does not allow you to go back and fix an error after the fee has been paid. According to USCIS, the top 2 user errors in the registration process are entering incorrect beneficiary information and entering the same beneficiary more than once. NPR. Think about what that means in practical terms. If your employer types your name differently than it appears on your passport, even a single letter difference, that registration can be invalidated. Even minor errors like a misspelled legal name can invalidate a selected registration and eliminate the opportunity to file the full petition. Employment law worldview. And once that $215 fee is submitted, it is gone. You paid for an entry that can never help you. This is not a hypothetical risk. Every year, USCIS processes tens of thousands of registrations with data entry errors, and every year, people lose their lottery spot not because they weren't qualified, not because their employer didn't want to sponsor them, but because someone entered a middle name incorrectly, or used a nickname instead of a legal name, or put in a passport number that didn't exactly match the travel document on file. So here is what you need to do before your employer submits your registration. Pull out your passport right now. Look at your full legal name exactly as it appears. Look at your passport number. Look at your date of birth. Ask your employer or their attorney to confirm those 3 data points match exactly what will be entered into the USCIS system. Do that verification before the fee is paid, not after, because after, you have no options. But this is where it gets complicated, because the fee trap is only the first of 3 major issues this season. The second one is even more consequential for your actual chances of selection. This is the first year that the H-1B lottery is no longer purely random. DHS published a final rule on December 29, 2025, implementing a weighted selection process that generally favors the allocation of H-1B visas to higher-skilled and higher-paid workers, while maintaining the opportunity for employers to secure H-1B workers at all wage levels. ABC 3340. What that means in plain English is that your position in the lottery now depends heavily on your salary level, compared to the prevailing wage for your occupation and location. Here is how the weighting works. The system is built on 4 wage levels. A level full wage offer receives 4 entries in the lottery. Level 3 receives 3 entries. Level 2 receives 2 entries. And Level 1 receives just 1 entry. Axios. That is not a small difference. That is a 4-to-1 advantage for someone at a Level 4 wage compared to someone at Level 1, in the exact same occupation, in the exact same city. For those who qualify for Level 3 and IV positions based on SOC code and worksite location, the newly introduced weighted selection will dramatically increase selection odds. In contrast, entry-level positions will face significantly lower selection rates. Axios. The practical implication is that if you are a senior software engineer, a principal architect, or a highly specialized analyst, being offered a salary that genuinely falls into the Level 3 or Level 4 range for your occupation and metro area, your odds this year are meaningfully better than they have ever been. But stay with me, because the next point affects your timeline and your registration strategy in ways that most applicants and even some employers are completely missing. The wage level assigned to your registration is not just about what your employer plans to pay you. It has to be tied to a specific SOC code, a specific worksite location, and the OEWS prevailing wage tables for that combination. If a beneficiary has multiple registrations from different employers at different wage levels, USCIS will place that beneficiary into the selection pool at the lowest wage level among all registrations submitted. USCIS, read that again. The lowest. Not the average. Not the highest. The lowest. So here's the scenario that is catching people off guard this season. A beneficiary has 2 employers interested in sponsoring them. One employer offers a Level YV salary, another offers a Level 2 salary. The beneficiary thinks having 2 registrations is better because it gives them more options. But under this rule, both registrations get weighted at Level 2. That beneficiary just lost the advantage of their Level 4 offer entirely, because the system penalizes the presence of a lower wage registration by pulling the entire entry down to the lowest level. If you have multiple employers considering registering you this cycle, this is the single most important conversation you need to have with an attorney before March 19th. Most applicants don't realize this specific rule exists. Most HR teams don't either. And that brings us to the third trap, which is the one with the most severe long-term consequences. The H-1B registration system is now what USCIS calls a beneficiary-centric system. And built into that system are fraud detection mechanisms that are specifically designed to identify people who are trying to game the lottery. USCIS is actively investigating registrations from past cycles, including FY 2023 and FY 2024, and is taking severe action against fraudulent multiple registrations. The Daily Caller. The beneficiary-centric system will level the playing field and reduce incentives for fraud and abuse, with each individual entered once into the selection pool, regardless of how many employer registrations have been submitted on their behalf. Fox Baltimore. The system uses passport numbers and biographic data to identify each unique beneficiary. Misrepresentation of material facts, such as falsely attesting to separate genuine job offers, constitutes fraud under the Immigration and Nationality Act and can result in a potential lifetime bar from immigration benefits. The Daily Caller, a lifetime bar. Not a denial, not a delay, a permanent, lifetime prohibition on receiving immigration benefits in the United States. Under beneficiary-centric selection rules, USCIS invalidates registrations that appear coordinated across related entities without a bona fide need. Shared executives, identical job descriptions, common work sites, or common payroll systems can trigger an investigation. News Nation. Let me give you a realistic picture of how this plays out. Imagine a software developer. Let's call him Aditya. He's been on OPT for the past year, he's been working hard, and his employer wants to sponsor him for the H-1B. Aditya also has a recruiter who suggests that a staffing firm could submit a second registration to give him better odds. The staffing firm and his actual employer are not related entities, but the staffing firm doesn't have a genuine, bona fide job offer for Aditya. They are submitting a registration purely to increase his chances of selection. That is fraud, And the USCIS fraud detection framework is specifically built to identify exactly this kind of arrangement. If Aditya's registration gets flagged, he doesn't just lose his lottery spot. He faces the risk of a finding that follows him through every future immigration application he ever files. Let's look at the facts, not the fear. Multiple registrations are not automatically fraudulent. The system does not preclude multiple registrations for legitimate reasons, such as when an individual genuinely has more than one bona fide job offer. Fox, Baltimore. The line between legitimate and fraudulent is the genuineness of the job offer. If two employers each have a real position and a real intent to hire, two registrations are legal. If a second registration exists purely to inflate lottery odds with no actual job behind it, that is where the system flags it, and that is where consequences begin. So what do you do right now? Here are the 3 steps you need to take before March 19th. Step 1. Do a data accuracy audit tonight. Before your employer submits or has already submitted your registration, confirm that your legal name, passport number, and date of birth in the USCIS system match your physical passport exactly. If your registration has already been submitted with an error, contact your attorney immediately about your options. Do not wait until after the deadline. Step 2. Have a wage-level conversation with your employer before the window closes. Ask your employer or their immigration counsel to confirm which OEW's wage level your offered salary corresponds to for your specific SOC code and worksite. If your salary puts you at level 3 or IV, make sure the registration reflects that accurately with documentation to back it up. USCIS may deny or revoke a petition if it later determines that an employer inflated a wage level to improve selection odds or subsequently reduced the wage below the level declared at registration. NBC News. The wage level you claim must be real, sustainable, and defensible. Step 3. If you are aware of more than one employer registration being submitted on your behalf this cycle, get in front of an attorney before March 19th and confirm that every single registration is tied to a genuine independent job offer, not a recruiter's speculation, not a staffing firm placeholder, a real position with a real employer who genuinely intends to hire you. If any registration doesn't meet that standard, the time to address it is now, while the window is still open, not after selection notices go out on March 31st. Here is the bottom line for this season. The H-1B lottery has changed in ways that reward preparation and punish shortcuts. Early workforce strategy, accurate wage level assessments, properly documented specialty occupation roles, and strict compliance with labor condition application requirements are essential to minimizing risk. MS Now. The people who are going to navigate this season successfully are the ones who treated registration not as a formality, but as the first line of their legal case. You have 12 days. Use them. Immigration rules change faster than most people expect, and this season has already proven that the new systems have real teeth. The only way to stay protected is to stay informed. Subscribe to this channel right now so you don't miss the next critical update before that March 19th deadline. And if you found this breakdown useful, share it with someone who is in the middle of this process. You might be protecting their future without even knowing it.